make it so it's mute. All right. Let's be on the record in case number 2019-CR1094, captioned State of Kansas versus Sean Michael Williams Sr. Would the parties announce their appearances, please?
May it please the court, State of Kansas appears by Assistant District Attorney Kyle Custer, appearing via Zoom.
May it please the court, Sean Michael Williams appears in person in custody and by counsel Zach Anthony, all via Zoom.
All right. We're here set down for a sentencing today. We were originally set for sentencing back, I believe it was in March. We tried to do it by Zoom because it was right after the pandemic started. Mr. Anthony was not able to reach Mr. Williams. Mr. Anthony was not able to reach Mr. Williams. One second. Is the defendant having difficulty hearing?
Just a little bit, Your Honor.
All right. Is this any better?
Yes, sir.
Okay. All right. So as I was saying, we were set for sentencing in March. We tried to do it by Zoom because of the pandemic, but Mr. Anthony was not able to reach Mr. Williams. We continued the hearing a couple of times to try and set it up for Zoom. We finally had to set it for an in-person hearing because the defendant was unreachable. The defendant did not appear at that hearing. It was bench warranted. Very recently, that bench warrant was returned and it was set for sentencing today. So with that, I have received the pre-sentence investigation and reviewed the same. The critical findings are as follows. The primary count of conviction is one of criminal threat, which is a severity level 9 person felony. The defendant's criminal history score was found to be that of C, as in Charles. That would leave him with a presumed sentence of probation with a presumed underlying term of 11, 12, or 13 months. If he has to do that time, he's eligible for 20% good time credit and subject to post-release supervision duration of 12 months. If he's granted probation today, it would be for a period of 12 months to adult court services. The second count of conviction was also criminal threat, a severity level 9 person felony. For scoring purposes, the defendant's criminal history score is considered to be I. That would leave him with a presumed range, again with a presumption of probation of 5, 6, or 7 months, the same 20% good time credit, 12 months of post-release, and 12 months of probation. Mr. Custer, I ask you first, did you have an opportunity to review the pre-sentence investigation? Any additions, corrections, or challenges thereto?
I have had a chance to review it, Your Honor. I don't have any corrections or additions to make to it.
Mr. Anthony, same question.
Judge, we have reviewed the PSI. We have no challenge to the criminal history score of C. In fact, we were well aware when we did this of the Johnson County case that gave rise to that score, as well as the old PSI in the Johnson County case when he was a G. So I was well versed in his criminal history score before we did this. There is no surprises on that, and I have reviewed all of that with him, and we have no challenge.
All right. Mr. Williams, you heard what your lawyer had to say. Is that correct?
Yes, Your Honor.
All right.
I just want to
hold on. There being no challenges, I will adopt the findings of the pre-sentence investigation for sentencing purposes today. Mr. Williams, as to the sentence today, I give you the last word. I let you hear what everybody has to say. Then I will ask you for your comments at the end of that, okay?
Yes, Your Honor.
All right. Mr. Custer, comments as to sentencing today.
Your Honor, state would just recommend the court follow the plea agreement in this case. All that really contemplates is that the parties recommend probation. State specifically would request that the court, as far as the underlying sentence, just have, not impose, but have the underlying sentence be the standard number on each count and run those concurrent today. I'd also ask the court to put in place a no contact order as a condition of that probation for the victims in the counts the defendant pled guilty to or pled no contest to.
All right. Mr. Anthony.
Judge, I have been in communication with at least one of the victims in the original information is a lady named Ruth. I'm blanking on her last name right now. But she has contacted my office several times, in fact, and I don't know that she would want no contact. Obviously, it's not my place to say that or not. But if the court is contemplating no contact with her, I would just ask that the court choose to title that no violent contact, or that we ask her to, make her own statement to the court. She actually attempted to come to court this morning. That was one of the things she spoke to me about, was that she wanted to be at court this morning. And when I told her it was Zoomed, I don't think she could ever figure that out. But anyway, neither here or there, just that small caveat. I would otherwise join in the state's request that you give this case two terms, mid-box terms, the 9C and the 9I, and that those be ordered to run concurrent. I know that just in that little brief sidebar before we got started here, I talked to Mr. Williams about this. He had obviously not showed up. He knows that was a mistake. It's not an excuse, but he was right at the very beginning of Corona when we were all still trying to figure this stuff out. He didn't have a valid cell phone that worked. My number was no good. He's not always been a resident of the Metro. And I think we were just unable to find each other, try and get this sorted out. So I don't think he intended any disrespect for the court. I have reviewed his Johnson County case. He certainly can do probation. That was a 36-month probation, I believe. So I don't think there's any reason to believe he won't be successful. And I think that this was just a bad set of timing and bad luck to some extent.
All right. Mr. Williams, now is your opportunity to tell me everything you want me to know in mitigation of your sentence today.
Well, I just want to start by apologizing, and my lawyer pretty much said it in a nutshell. It was just the COVID had broken out and just miscommunication. Numbers were lost. I kind of was moved around, and that's basically the story, sir. And I apologize again.
All right. Well, let me ask you this. How did you end up in jail?
The Bell's guys came and picked me up.
Okay.
I had no idea that I contacted once I got word that they were, looking for me. I just thought maybe it might be an amnesty for the COVID, once it blew over, or, I was working on my job is on the line right now. They're wanting me back by the 2nd to be able to keep my job, to be able to get out and be a citizen and provide for my family. I have young children at home. They need me. But just was alerted by family about the Bells bombing, and I was trying to get my next check to come in and turn myself in, but they found me before that I was able.
That happens all the time. All right. Where are you working?
LC Distribution in Kansas City, Missouri.
How long you been there?
It's about 4 to 5 months.
What do you do for?
I'm an order puller, sir, Your Honor.
All right. Well, look, I don't think you just forgot about your case, and I don't think you were unable to reach anybody, because if you're working, you're making money, and needless to say, I'm sure that somebody would be able to allow you to pick up a phone at work and go, hey, maybe I didn't show up for my sentencing. I think there might be a bench warrant for me. But in any event, and look, after 6 months or whatever it was after your sentencing date, or 10 months or however long it's been, they just happened to get you right before you decided to come back in. That pretty much, when I hear that which I hear from everybody who gets arrested, that, oh, it was just the day before I was about to walk in after 10 months. But in any event, look, you've got a presumption of probation. You're going to get probation today. But if you perform on probation like you did on bond, it's going to be a really short time and you're going to go to prison.
Oh, no, sir. You don't have to worry about that, sir.
All right, Mr. Anthony, any legal reason why I should not now proceed to sentencing?
No, Judge.
All right. For count one, the criminal threat, a severity level 9 person felony, criminal history score of C, the defendant will be sentenced to the standard range of 12 months. If he has to do that time, he'll be eligible for 20% good time credit, subject to 12 months of post-release supervision. His application for probation is considered and it is granted to adult court services for a period of 12 months. As to count two, that also a criminal threat, severity level 9 person felony, criminal history score I, he will be sentenced to the standard range of 6 months. Again, 20% good time credit and 12 months of post-release supervision duration. His application for probation in this count is also considered and approved for adult court services for a period of 12 months. Given the defendant's performance on bond, his sentence in count two is ordered to run consecutive to the sentence in count one. All right, Mr. Williams, what that means is if you do your probation like you tell me you're going to do, then it will have no effect whatsoever. But if you just decide to disappear for a number of months again, you're going to not have to do 12 months. You're going to end up doing 18 months. Does that seem fair?
I understand. Yes, Your Honor.
All right. All right. So let's talk about, it sounds like defendant is gainfully employed. So I don't see any reason not to impose court costs and supervision fee in this case. So those will be imposed, as well as Mr. Anthony, do you know what your attorney fees are?
Judge, I believe I'm retained on this case.
Okay. All right. So there's no issue there. This is, let's see. These other felonies, there at least one of them's in Kansas, so his DNA should be on file. He should not need to pay a database fee. There is no fine. There was no request for restitution. So those are all the costs and fees in the case. I am going to order no contact with the victim in this case, Miss Ruth Morales. Mr. Williams, here's what that means. I'm not going to order you not to have contact with her. It doesn't sound like that's what what she wants and what you want. But I am ordering no violent contact, which means if you guys get in a dust up, I need you to know this. Your fault, her fault, nobody's fault. That if their cops are called out because you and Ruth get sideways with each other, you're the one that's going to pay the price. You understand that?
Yes, Your Honor.
Okay. So she gets mad at you for no good reason and she attacks you and the cops get called out there. Sounds like it's all her fault. Doesn't matter. There was violent contact between you two and that's a violation of your probation. You get that, right?
Yes, sir. Yes, Your Honor.
All right.
I have a question.
Yes, sir.
Will I be released today?
Yes, you're gonna, well, I'm gonna sign your release today. I'm assuming they're not overloaded, so they'll get you out today.
Thank
I
you.
expect that that's the case.
Thank you so
What do we
much.
know about jail time credit? Mr. Custer, Mr. Anthony?
Judge, I'll look. He's been in custody since he was picked up on this, so it'll be the dates of the PSI plus whatever that is. So I can look it up in Jim's. It'll be 3 days in early September, which were the dates on the PSI when he was originally picked up. Plus, I can do it right now.
A month.
But it'll be this most recent stint. It won't be a ton of credit.
Okay. All right. Well, you two figure that out, put it on the journal entry, and we'll get it done. All right, Mr. Williams, you have 14 days from today to appeal anything you don't like about your sentence. You also may be able to seek expungement of this conviction after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm. certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons.
Right.
But if you have any questions about that, Mr. Anthony, you can reach out to Mr. Anthony.
Okay.
All right. Mr. Custer, anything I failed to cover today?
No, Your Honor.
Mr. Anthony.
Yes, Judge. Nothing you failed to cover, but I have done the jail credit. He was booked in on October the 26th. That's 10/26, and today is 11/30. My little computer program tells me that's 36 days. My program is inclusive, so sometimes the state comes up with one less day because it's not inclusive, but I believe those dates are correct, plus the 3 days that were on the PSI from September of 2019.
All right, he'll be granted that credit. All right, so Mr. Williams, here's what you need to do. As soon as you get out, if you're out before close of business today, I need you to go over to the probation office, which is the first building to the north of the building you're in right now, okay?
Yes,
And
sir.
report in. If you don't, do you have pen and paper or anything to write this number down with?
No, I don't, sir. I know where you're talking about.
Okay, all right. Look, if for some reason you're not out by close of business today, I need you to call them first thing and find out what you're supposed to do.
Okay.
Can you find that number? If you can't find that number, you call Mr. Anthony and he will get you there, okay? But
Yes.
you need to do that immediately. If you get out today and they don't hear from you for 3 days, we're gonna be sideways again, all right?
Yes.
Your Honor,
yes.
go ahead and give me that phone number. I'll write it down for him.
All right, it's 913-573. Now here's where I get stuck. We're off the record now, Ms. Hunt. Because I know community corrections by heart. What's court services? Anybody?
I have it. Give me a second. I've got it on my little list of cheat sheet numbers here.
I have Mr. Jones's number.
It's 2846, Judge. 573-2846 is court services.
You get that, Deputy?
Yes, sir.
Appreciate it. All right. Anything else we need to talk about before I let you all go?
None from the state, Your Honor.
Nothing from defense.
All right. Good luck to you, Mr. Williams.
Thank you so much, Your Honor.